this was mentioned by Mr. Chen early this morning, then he reiterated it. But what caught my attention is the presentation of the gentleman from Thailand, Mr. Parapot, when he mentioned that there was an MOU with Thailand, and later a joint venture that resulted in an actual production of oil. Although, of course, the time span was rather extended. But I'd like to address Mr. Chen. Is this something that China, you think, can consider on a one-on-one basis, 50-50, in an area that is maybe neither in the Philippine EEZ or in the China EEZ, perhaps in that little hole in the middle of the South China Sea?
Thank you very much. Before turning to the panel, one more question from the lady, and then we'll come to the panel.
Good afternoon. This is Clara Asuncion. This will be very brief in relation also to the question raised by Congressman Golez. This is for Ambassador Chen. It appears that the common message for all our speakers from today's forum on finding the right solution to the problem is towards a peaceful cooperation by all claimants, as well as involving the non-claimants to the dispute. Now, in the light of the fact that for China, Ambassador Chen, there are installations that were erected in Mischief Reef, I would like to raise the question as to, are these installations subject for joint cooperation for the claimants as well, in the light of the statements you have made? Thank you.
Thank you very much. I'd like, since Fraser Cameron has to leave for the airport, I'd like to see whether he would like to respond very quickly to some of those comments. And then after that, I'll turn to the ambassador to respond to the questions of joint development that were raised by the other two interventions from the floor. But if there's anyone else on this panel who wants to chip in, please feel free to do so. Fraser.
One of my first jobs in the Foreign Office was dealing with what we called the Falkland Islands and the Argentinian Las Malvinas. We were trying to convince the Falkland Islanders to accept a deal of joint sovereignty. And we were working on this very hard when the military junta took over in Argentina, subsequently invaded the islands, which made Thatcher respond. My point is that you have to take into account so many different factors: history, geography, capabilities, intentions, economic interests, and also the international climate. Now, I think the international climate has changed over the last 40 years so much that the military aspect, while important, has declined. And therefore, it will be very difficult to use force in today's world to gain something that the rest of the world does not accept. There would be huge consequences, I think, to pay. But this means the onus should be now on using the time available to try and develop as many practical areas of cooperation as possible. And there's been quite a few suggestions put forward over the previous day and a half. So my concluding message, if you like, is that put the effort into understanding the position of the other side, look for the gains, and we've seen how important these gains can be in the Malaysia-Thailand agreement. There are huge potentials, I think, for a win-win situation out there. And this is the purpose of conferences like this, to come up with ideas and then push governments to sell them. So in that sense, I think it's been a very valuable and useful occasion, Mr. Chairman.
Thank you, Fraser. And travel well. Ambassador Chen, Peter Galbraith, and maybe Vera Bob might want to add to this question of joint development. Ambassador Chen, please.
I think those questions refer to the issue of joint cooperation or joint development. has already explained what will be the purpose for the joint development and what will be the right time for the joint cooperation and on what programs. First, joint cooperation will precede the final solution of the issue of the conflict, the disputes. Because, as we see at the moment, it's not feasible and possible to reach agreement for the final settlement of this disputes in the very near future. For reason why I'm not going to elaborate, but it's easily understood. Then the people were asking, yesterday they were asking, what will be the next? So we can't remain without moving forward. Because South China Sea is a vast area with vast potentialities for development. We cannot impede our development. All the countries around this area badly need it. So that's why, this is the reason the late leader of China, Deng Xiaoping, with his wisdom, proposed that, well, let's put aside the issues of disputes and find a way for development, for joint development. And we are following the practical wisdom and a way of thinking, and we feel that this is a practical way of doing it. Of course, it remains to be negotiated, to be discussed, to be agreed where to start. As I just mentioned, that we can start with non-controversial areas or less sensitive areas. It is a step-by-step process. Once we start, we will find the way or next step, I'm sure. But I can't answer what will be the next. When we start, what will be the next project? No, because this is not decided by China. It will be decided by two parties, or even by three parties and 20 parties. Not China alone can decide on this, how, when, and where. This is my answer to your question. You may not be satisfied, but this is what I can tell you at the moment. Thank you.
Thank you very much. Peter Galbraith, quick comment. Thereupon, and then I'll take further questions from the floor.
The issue on joint development, first is, in the end, it's about the development of major resources. Fisheries, on one hand, access to fisheries, but certainly the development of hydrocarbons. That's what we're really talking about. And while joint development can sound right in principle, and it's a wonderful idea, what really matters is fairness. Now, as between Malaysia and Thailand, who maybe had, each of them had quite plausible reasons for their claim, it was fair. Joint development was in fact what Indonesia and Australia had, and what Australia wanted East Timor to also engage in. But from the point of view of East Timor, it was grossly unfair because if they went to the International Court of Justice, they clearly would have gotten a demarcation at the midpoint between the two countries. And so, when you're thinking about this, I think it was very helpful in our negotiations to be thinking, what would a court do? What would the ICJ do? And that was an option for us. In the end, we didn't have to use it. But what would the ICJ do? And one of the elements, again, that is applicable, I think, to the South China Sea is that the ICJ will recognize for liberal states the territorial sea, the EEZ, and with regard to small islands, they will be significantly discounted the size of the EEZ. Look at the John Mayen case. And if the islands are utterly uninhabited, they may be given very little weight. That then can guide you in terms of what area might be subject to joint development for hydrocarbons or the ratio of sharing. One final point, and I should have made it in my presentation. One of the reasons that we had a successful outcome in the negotiations with Australia is that the experts on the Australian delegation who were handling law of the sea knew that our case was correct and that their case was no longer valid international law. Now, they never said that to us, although one of them had written his doctoral dissertation making exactly that point, and we hadn't. But they clearly were people who were telling their political masters, you know, your case is a weak one. And because, in fact, Australia wanted to do the right thing, that message got through. And that's why, in the end, I also think that this kind of dialogue and discussion, and always the reference to what is fair, to the standards that are out there, probably are going to be useful in moving the sides to a fair agreement, whether it's joint development or something else.
Thank you, Peter. Very well. Quick comment, and then we'll take questions. I have a hand there, a hand there. Anyone from this side of the room?
Okay, responding to Honorable Congressman, I was just wanted to mention that you mentioned that it was quite a lengthy time span, but there are many models of JDA, and if you go opt for a less sophisticated regime, it could be much quicker. Now, as to the time the oil companies need to do all the survey, that I remember was in the 80s, and with the new and modern technology advancements, I'm sure it's much quicker. That's one. Another thing is for the case of Malaysian Thailand, we didn't opt for the legal solution or to third-party adjudication, mainly because we knew that going to the ICJ is costly. It would create quite an impact on the people of the two sides. You imagine how the newspapers and everything will respond to, especially when Thailand had lost a case in 1967 in the Khao Pravihir case. And so the main reason basically is also the economic impetus. When the oil companies made a presentation to both countries about how much resources, their potential resources, and the huge revenue that's there, we had to think twice. And this was the solution both countries choose. Thank you.
Thank you very much. Lady over there, gentleman over there, and gentleman over there. Yes.
I'm Ellen Tordesillas, I'm a journalist in the Philippines. I'd like to address some questions to Ambassador Chen. Ambassador Chen, is China willing to have these conflicting claims in South China Sea adjudicated in the ICJ or UNCLOS, International Tribunal Law of the Sea?
Thank you very much. Gentleman over there, and then there's a gentleman over there.
Thank you, Mr. Good afternoon. May I be allowed to address question also still joint development for Ambassador Chen? May I relate, Mr. Ambassador, the South China Sea issue with China as the anti-trade agreement? Because China has an FTA with ASEAN, you would would China be willing to open or allow ASEAN investors in, say, cells, so that the products that they can be exported to China duty-free under the China-ASEAN FTA? And if possible, for products that can be extracted from South China Sea, for example, hydrocarbons, to be covered by the ASEAN-China FTA so that it can be exported to China also duty-free. Thank you.
Thank you very much. Gentleman over there. And then, I can't see the lady. And someone over there.
Well, thank you, Mr. Chairman. My question will be addressed to Mr. Chen. But I want to say that...
Can you identify yourself, please?
My name is Professor Yen Song. I'm from Academia Sinica, Taiwan. I agree that we should pay more attention to rule-based solution, rules-based international system. As all of you know that 1982 United Nations Convention of the Law of the Sea is the constitution for the ocean. As July this year, 162 parties. For the region, South China Sea, I consider this convention as a constitution for functional cooperation. Functional cooperation in the South China Sea. Now, what about rules-based? Article 122 defines South China Sea as semi-inclusive. Article 123, paragraph A, paragraph B, indicating that we need to cooperate. We have the treaty obligation to coordinate, to manage, conserve, protect limited resources in this South China Sea, semi-inclusive. Paragraph B says that we have to implement those rights, duties, according to the convention, to protect marine environment. Now, Mr. Cameron left. EU experience, fishing and environment. It's very important that 300 million people living in this region depend upon protein, source important fish resources. Now, my question is it possible, is it necessary to establish the South China Sea Regional Fisheries Management Organization based upon Article 123, paragraph A? If that's possible, then we are talking about joint development of fisheries resources based upon the Constitution for the functional cooperation in the South China Sea, as I mentioned. Second question, if that's the case, Professor Hashim Jalal, Ambassador Wisner, and so on, say that all-inclusive approach should be taken. All parties concerned should be included. If that regional fishing maritime organization established, should Taiwan be invited based upon the precedent WCBFC fishing entity, based upon the precedent World Health Assembly health entity, based upon APEC precedent economy? Should Taiwan be included in that organization? Thank you, Mr. Chairman.
Thank you. One last question before we turn to the panel.
I'm Roilo from UK. So I'd just like to ask Mr. Gilbert, based on your experience, is the 9-dash line claim of China, is it a weak or strong claim? Is it valid under international law, and is it fair? The second question is to Mr. Wayne, where you said the doctrine would likely be rejected by ASEAN. What is your basis for saying this? And thirdly, to Mr. Chen, why does China lobby against ZOFIT? Is it not a viable solution to the problem?
Thank you. Because most of the questions are directed to Ambassador Chen, I will start with the questions directed to Ambassador Galbraith and to Barry Wayne, so that Ambassador Chen can collect his thoughts and respond to those very nice questions that have been presented to him. Peter.
If the 9-dash line is a claim to the sea, then I think it is a claim that has no basis in current international law, because the way in which territorial seas and EEZs are delimited, there are specified distances, and where they overlap, and the coasts are opposing, the principle of equidistance applies. There may be some modification in adjacent coasts taking into account of small features. Does a Thai island count or does it not, or what weight do you give it? If we are talking about territorial claims to islands, then there are separate principles that would apply that have nothing to do with UNCLOS. The history of the claim, settlement, discovery, there are all sorts of principles, but they're much less well defined, because fortunately in the world there are very few bits of territory whose possession is, which is like these islands. But if you're talking about the effect of those islands in terms of the seabed, that is in terms of the maritime resources, then the effect of those islands under current international law should be very small. Yes, whoever ultimately gets them may have a territorial sea of 12 miles if it doesn't overlap with other claimants. They may have some small EEZ, but certainly not 200 miles, and certainly wouldn't weigh against the claim of a large littoral state. Under international law, I think the littoral states would have a significant EEZ up to the territorial waters of these small uninhabited islands, if in fact they're islands at all.
Thank you. Barry?
Yes, I would stress that it's not my personal opinion about the Philippine proposal for a zone of peace, freedom, friendship and cooperation. It's my belief, after discussing it with the senior ASEAN officials who have been discussing it now through 2 meetings, and my understanding is that the Philippines does say that this zone of peace, this ZOPFIC as it's called, can be presented as part of the DOC, that it's a natural part of the program to go on with. There's serious doubts among some of its fellow ASEAN members about whether this is so. The ZOPFIC, one of the early problems it encounters is the 9-dash line. It assumes that the 9-dash line is illegal under international law, particularly under UNCLOS. Now it may well turn out to be, as my colleague here just said, the 9-dash line may turn out to be illegal, but until it's clarified, one doesn't know that. The DOC does not separate disputed areas from undisputed areas, and ZOPFIC seeks to do that. So the ASEAN legal and other technical specialists here in Manila last month grappled with this and the political implications as well, and the senior ASEAN officials grappled with it last week in Bali, and there's just simply so many questions. It seems to go on, and there was at last week's meeting in Bali, as I understand it, I can't give you the technical reason, but the Philippines interpreted one aspect of international law, and I can't cite it, in a way that worried the other ASEAN members that might interfere with their own positions, and that was made clear particularly by Vietnam and Malaysia. So, all things considered, I think a number of them have gone so cold on it, and as I told you already, among the non-claimants, under Chinese pressure, Laos and Cambodia did not even send a specialist to that meeting. So, putting all things together, based on my conversation with senior officials, I believe the decision will be made before too long not to adopt it as ASEAN policy.
Thank you. Ambassador Chen.
Yes. After the explanation of Mr. Wang, I don't think that I need to elaborate in detail. So, there are 3 points. First, about interrupted lines. What's the relationship between the lines and international law? First, I would say that that UNCLOS does not deal with the sovereignty of the islands, while it deals with the maritime issues, that is maritime rights mechanism. So when we come to the rights of the sea areas, then we might resort to the provisions of the convention, but not the sovereign rights of the islands. So this is clear. Second, I think a lady mentioned about, she put the question about how about she present the case to the ICJ and the Tribunal for the Law of the Sea, to which I have 3 points to tackle. First, the ICJ and the Tribunal of the Law of the Sea let me put it in a way that theoretically you can put a case on territorial sovereignty to the ICJ for judgment. In principle, in international law, this is right. But technically, I tell you, that China does not recognize the jurisdiction of ICJ. This is a technical obstacle. But the main point is that it's an established and well-known position of the People's Republic of China. It's a foreign policy. It's a fundamental principle of China's foreign policy. That is, to solve any dispute, international dispute, through peaceful negotiations and consultations, especially the questions between friendly countries. This is our first choice, priority choice. Thirdly, no country or no claimant has formally proposed that option. I believe there are various reasons for that. But first of all, we prefer to solve it by negotiations. That's why we have entered so many political agreements with our neighbors. I mean, the main agreements, just I mentioned in my final remarks. Why should we present the case to others while we have the right, while we have the ability, the wisdom to solve it among ourselves? Thank you.
Thank you very much. Ladies and gentlemen, we have come to the end of our session. We have had a rich discussion with many interesting viewpoints put up by our panel as to the way forward. At the risk of oversimplifying the discussion, I will attempt an imperfect summary. Because we have come from different parts of an extraordinarily diverse region, which we call the Asia Pacific, we are bound to disagree on a number of the issues relating to conflicting claims in the South China Sea. Because we come from countries and entities with very different interests, with very different histories, with very different nationalisms, with very different identities, it is surprising that we have as much in common as is evident that we have. Nevertheless, I believe we are in substantial agreement in three areas. Firstly, we are in substantial agreement that the issues relating to the South China Sea are complex and difficult and unlikely to be resolved in the foreseeable future. Secondly, we are substantially in agreement that the way forward must entail a focus on how to manage our differences, even as we acknowledge that we cannot resolve them completely. That the way we manage our differences must not disrupt the growing economic links, which is evident in the growing economic integration within our region. This was Secretary Xiaosong's key message this morning, and this is Ambassador Chen's key message in his presentation. Thirdly, I believe we are substantially in agreement that any way forward must entail pragmatism and flexibility. When Peter Galbraith describes the successful resolution of that very lucrative piece of territory between Australia and East Timor, the key message there is focus on interests, focus on common ground, and not on differences. When Virapod described the successful experience with the Malaysian Thai development area, again the key message is focus on common benefits and not on what divides. When Barry Wayne described that agonizing, frustrating process in terms of agreement between ASEAN and China in relation to the declaration of conduct in the South China Sea. There are two ways to look at it. One is that nothing is simple with respect to the South China Sea. Two, pragmatism and compromise helps, because there was a major leap forward with ASEAN's pragmatic withdrawal of wordings which should probably not have to be withdrawn, but which made very little difference. This is wording relating to the fact that ASEAN would confer before its consultations and discussions with China. So I believe that whatever position we may take, we are bound by a common acknowledgement as to the value of pragmatism, flexibility, and compromise. This reminds me of a distinction that a mathematician once made between two kinds of games in life: finite games and infinite games. Finite games are games which have a beginning and an end, and result in a winner and a loser. Infinite games have no beginning and no end. The aim is not to win, the aim is to keep on playing. Following the discussions which began yesterday evening and which have concluded with this session on the way forward, I'm struck by how our attempts to manage our differences in a peaceful manner are a little like an infinite game. The aim is not to win. The aim is to keep playing and keep engaging. And with that, I would like to invite you to join me in thanking our excellent panel and to thank the Carlos P. Romulo Foundation and its chairman, Bobby Romulo, you are quick to say. I've just been reminded that these are not the last words. But as chairman of this session, I think we owe it to the Carlos P. Romulo Foundation and to Bobby Romulo for putting together what is not easy to bring together. A group as diverse as this from across the Asia Pacific to discuss something as important, as complex, and as difficult as this stretch of water that we call the South China Sea. Thank you.
Ladies and gentlemen, we've come to an end, but I am compelled to give you some ending thoughts after following a rather articulate and eloquent friend of mine, Dr. Timothy Ong. And in many ways, I do echo the sentiments he has just expressed. But overall, there has indeed been progress in managing the disputes, even though the resolution of the substantive issues themselves, sovereignty and joint development, have still a long way to go. Discussions on the Code of Conduct are underway, and an agreement between China and Vietnam was recently signed. There are joint actions in non-sensitive areas that can indeed help diffuse tensions and build confidence, such as scientific research, navigation, environmental protection, etc. There is greater clarity in understanding the positions of the claimant countries and the reasons for the interest of non-littoral states. there is also greater understanding of the context within which countries have acted and reacted to the developments of the SES, and the SES must be recognized and taken into account. That the issue is not just between China and the rest of ASEAN, but also within ASEAN itself that need to be resolved first. That the interests of external powers have raised the stakes and complicated the issue, but at the same time have increased pressure on claimants to settle the dispute among themselves. That all parties, without exception, have important and intertwined economic relationships that militates against action which might harm these relations. Overall, I think more signs point towards accommodation and resolution than for conflict, contrary to the gentleman I cited in the beginning of this session, that Mr. Long, that was quoted in the Global Times. I also conclude by saying that I'm particularly delighted that Ambassador Chen has found these sessions useful, and I thank China for joining us. I only hope that a few sleepless hours I've had the last few days, my wife will find that also useful. Thank you very much indeed.